All right, good afternoon, everyone. Happy Friday. We made it to the end of the week, and this is the best part of my week because I get to be here with an incredible panel of speakers on a very important topic of voting rights and how you can get involved. So, thank you for being here. Thank you for taking the time to learn with us, and thank you for being in community to be a part of this very important discussion. So I'm going to skip over housekeeping announcements for the sake of time, and I'm going to directly go into introductions of who we have here today. So first off, we will have Matletha Benet. She's senior staff attorney in the Voting Rights Practice Group for the Southern Poverty Law Center. Born in the small agricultural community of South Bay, Florida, Matletha was a first-generation college graduate from the University of Florida, obtaining a bachelor's degree in political science and English. After being inspired to become a public interest attorney and graduating with her Juris Doctor of Law from the Florida State University, she worked as a criminal defense attorney for the Capital Collateral Regional Council, representing indigent capital clients in their post-conviction appeals. Most recently, she has served as legal and legislative advisor to the Florida Senate Democratic Office, providing analysis and input on election laws, as well as criminal and civil justice policies. She has worked with community organizations, national experts, and political figures on a variety of legislation, including the implementing bill for Florida's Amendment 4, which hinged the right to vote on the payment of financial obligations, and the recent elections laws that dilute and disenfranchise the vote of thousands of Floridians. Next, we will have Cecile Schoon, president of the League of Women Voters of Florida. Cecile received a visual and environmental studies undergraduate degree from Harvard in 1981. After graduating from the University of Virginia School of Law in 1984, she spent 5 years as an active duty Air Force JAG prosecutor. Cecile currently serves as the president for the League of Women Voters of Florida and is the first Black woman to serve in this capacity. She is a past president of the League of Women Voters of Bay County, previously served as chair of the Florida League's efforts on restoration of rights, including passing Florida's 2008 Amendment 4, as well as heading up the Health Care Action Team. She is also a proud member of the Chi Omicron Omega chapter of the Alpha Kappa Alpha sorority. We will also have Jack Jenberg, who is a senior staff attorney with the Southern Poverty Law Center. Jack is a senior staff attorney with the Southern Poverty Law Center's Voting Rights Practice Group, where he litigates redistricting and other voting rights cases in Florida, as well as redistricting cases in Georgia, Alabama, Mississippi, and Louisiana. Prior to joining SPLC, Jack practiced civil and criminal litigation at law firms and clerked for a federal district judge in Atlanta. And finally, we will have Neil Bowles, who is Deputy Director of Florida Rights Restoration Coalition. Neil has more than 25 years of experience working as a public servant and community advocate. Before joining the Florida Rights Restoration Coalition, Bowles worked as chief of staff for a member of Congress and staff director for a full congressional committee, as well as the outreach director for one of the fastest growing churches in the country. While in Washington, Bowles helped negotiate and secure passage of the Help America Vote Act, which has improved voting accessibility and accuracy for millions of people. Bowles is the author of the book Into the Sun and speaks to local, state, and federal organizations about his work on Amendment 4 in Florida and the experience that led to and followed his own felony conviction. He was named a top hired gun in the Hills newspaper annual list of top lobbyists and named to Roll Call newspaper's list of 50 most powerful Capitol Hill staffers numerous times during his career in Capitol Hill. So I reiterate, I'm humbled and honored to present all of these people, these wonderful panelists to you. I will turn it over to our moderator, Sabrish, who I did not introduce, but needs no introduction. It is to you, Sab.
Thank you. Good afternoon, everyone. Thank you for joining us today. My name again is Sabrish Neelakanta. I'm a civil rights attorney in West Palm Beach, Florida. I'm also the chair of the Civil Rights Committee for the Public Interest Law Section, who is co-sponsoring this very important CLE. I'm really honored to have everyone here, all the panelists here, and I want to get right to it. The format of this CLE will be as follows. It'll be approximately 1 hour. We'll divide it into 4 separate sections. First, Mathlita Bennett will speak about the introductory sort of foundations in election law, sort of give us a historical background into a lot of these issues. We'll move to Cecile Schoon, who will then discuss recent Florida legislation and legal challenges that are present here in Florida. We will then go to Jack Gemberg, who will discuss the redistricting process and the overview of the local and state and federal redistricting challenges that have been going on here in Florida. And of course, we'll then move on to Neil Volz, who will talk about his work in voting rights restoration and the work and recent challenges associated with that. At the end, I hope that I encourage everyone to submit questions. If you look at the bottom of your screen, there is a chat option. If you can kindly just submit your questions there, I will collect those and ask those of our speakers at the end. And I also encourage our speakers to speak about what everyone can do here to get involved in voting rights issues here in Florida, since it is a vitally important matter. With that, I will take it to Mathlita.
Hello, everyone. Good morning. Well, good afternoon. My name is Mathlita Bennett, Senior Staff Attorney for SPLC. And today, as my colleagues will provide and go into further detail on the specifics of Florida legislation and issues going on related to voting rights, I wanted to sort of provide a framework and context for a lot of these election laws. So I'm hoping that this will be helpful to you as we delve deeper and allow you to really think more critically about a lot of the issues that are going on as you see historically and federally how a lot of these protections came about. You can go to the next slide. So U.S. election laws date back to Article 1 of the Constitution, which gave states the power to prescribe the time, place, and manner of congressional elections. Even so, this clause also vests the ultimate power in Congress when it talks about that Congress has the power to at any time make any changes or alterations to these regulations. Additionally, there are constitutional amendments that prescribe the right to vote. The 15th Amendment gave African-American men the right to vote. The 19th Amendment gave American women the right to vote. The 24th Amendment eliminated poll taxes, and the 26th Amendment lowered the voting age to 18. Additionally, the Equal Protection Clause of the 14th Amendment also prescribes voting rights protections. So although the denial of the right to vote violates the 15th Amendment, election statutes that treat white and Black voters or candidates differently can also constitute a denial of equal protection as well. And so the voting rights protections that you'll hear about subsequently sort of flow from these 4 corners of the constitutional framework to provide the protections that we have today. Next slide. So this is a compilation of federal voting rights laws that provide protections for all aspects of voting and protect the right to vote for different groups of people. So I'll sort of go through and summarize. And if you have any additional questions, I'm happy to answer. So the Civil Rights Act of 1870 is also known as the Enforcement Act, or the first KKK Act, or I believe the Force Act. It was one of the earliest protections against discrimination in voting. So although the 15th Amendment was adopted mere months before, there were violence in different efforts to interfere with the rights of African Americans to vote, and it remained a barrier to their equal participation. And so the Civil Rights Act primarily expanded the criminal jurisdiction of the federal courts and adopted criminal penalties for those using violence to prevent African Americans from voting. It has been amended multiple times over the years to expand enforcement. So many of you probably know the Voting Rights Act of 1965. It is widely considered the single most important federal statute protecting the right to vote. And so with the rising tide of violent attacks, with those trying to carry out the 15th Amendment, many began to wonder prior to Voting Rights Act being adopted, if the existing civil rights laws would ever be properly enforced by local authorities. So the actions of activists such as Fannie Lou Hamer and the notorious Bloody Sunday attacks that occurred in Selma, Alabama, the Voting Rights Act was adopted as an additional enforcement mechanism for the 15th Amendment. It has been expanded to protect other voters, and I will go into detail on some key sections a little bit later. The Voting Accessibility for the Elderly and Handicapped Act of 1984 requires polling places across the US to be physically accessible to people with disabilities for federal elections. The Uniformed and Overseas Citizens Absentee Voting Act, as well as the Military and Overseas Voting Empowerment Act, require that the states and territories allow certain groups of citizens to register and vote absentee in elections for federal offices. And so those covered citizens would include people such as members of the armed forces, their family members, and US citizens that reside outside of the United States. The National Voter Registration Act, or what is known as the Motor Voter Act, was enacted to combat the arbitrary and complex voter requirements that were enacted after Reconstruction. And so while the explicit disenfranchisement made illegal by the VRA in 1965 was outlawed, voter registration remained a huge obstacle, and it contributed to low rates of voter turnout. So the NVRA required states to provide the opportunity to apply to register to vote for federal election by 3 means. So one of them was when you go to apply for a driver's license or renew your driver's license, you have probably been asked to update or to register your voter registration. If you have visited an office that provides public assistance, such as a SNAP, WIC, or Medicaid office, they will also talk to you or ask if you want to register or update your voter registration. And it also prescribed a federal form so that states could allow citizens to register to vote by mail. So the NVRA only covers 44 states because the other states have no voter registration requirement and continually offer election day registration. The Help America Vote Act primarily authorized funds to help states improve election administration and replace outdated voting equipment. It created minimum standards and established the U.S. Election Assistance Commission, which assisted states with compliance. Next slide. So out of all the provisions within the Voting Rights Act, Section 2 continues to have arguably the greatest impact. So in 1980, the Supreme Court held that Section 2, as originally enacted, was a restatement of the protections afforded by the 15th Amendment. So accordingly, under that standard, a plaintiff had to prove that a challenge standard or practice was enacted, at least in part, by an invidious purpose, so racial bias. Of course, this was a very difficult burden. So in 1982, Congress concluded that Section 2 should be amended. And so rather than focus on discriminatory intent, it amended the statute to focus more on discriminatory results. And so a plaintiff could therefore establish a violation if evidence established that the totality of the circumstances rendered the statute had the result of denying a racial or language minority an equal opportunity to participate in the political process. And so with this amendment, the Senate committee issued a report. And in that report, it suggested several factors for courts to consider in the totality of the circumstances analysis. I won't go through all of the factors here, but these were different factors that courts could consider as they analyze different electoral devices or practices. And so additionally, the Village of Arlington Heights versus Metropolitan House Development Corporation also added additional factors, basically where if a challenge practice was adopted, it would a court would ask and determine whether or not it would harm minority voting strength and not merely with an expectation that it would do so. And so Section 2 cases primarily fit into two categories, vote dilution and vote deprivation. You often see Supreme Court cases addressing vote dilution, which are primarily redistricting cases, which my colleague will speak about later. Vote deprivation cases don't make it as often to the Supreme Court, but there are many throughout the states that address these issues. Next slide. So voter accessibility are protections in place to ensure that people with disabilities or language barriers can vote. It is couched in multiple statutes. One well-known statute, of course, is the Americans with Disabilities Act. It's modeled after the Civil Rights Act. So the specific protections for voting are contained in Title II, where the discrimination by any public entity is prohibited. So voting would be considered, in the election administration will be considered a public entity for the purpose of the ADA. And I already mentioned the National Voter Registration Act and the Help America Vote Act. Next slide. So Section 203 and Section 208 of the Voting Rights Act both provide requirements for accessibility. However, they do it in two different but complementary ways. Comparatively, 203 is often seen as a narrower protection, while 208 acts as a broader catch-all. So 203 requires election officials to provide language accommodations such as signage and translated voting materials in certain covered areas that reach a threshold number of residents who predominantly speak a language other than English. And so under Section 203, there is a formula that is used to determine if a state or county is covered, and that list is published in the Federal Register every 10 years. Currently, the languages included are, I believe, Asian, American Indian, Alaska Native, and Spanish languages. Florida has statewide coverage for Hispanic languages, and 14 counties specifically have coverage for Hispanic languages, and 1 county has coverage for Seminole languages. So comparatively, Section 208 came about because while Section 203 was very specific to covered communities, many began to wonder, like, what about voters with limited English proficiency that don't live in a covered community, or those with a disability? So 208 adds protections for individuals who need assistance, regardless of their specific language, limited English proficiency. Those individuals can receive assistance from their person of choice other than their employer. It covers voting assistance for blind, disabled, or illiterate persons, and compare it to Section 203, which applies to certain covered places, applies nationwide, and is not subject to any formula. Next slide, sorry. There is disagreement among many voting rights experts on whether states should require voter identification to vote. So proponents see it as a way to increase, to prevent in-person voter fraud and impersonation. However, opponents say there is little fraud of this kind, and the burden unduly restricts the right to vote and imposes unnecessary administrative burdens. So most states do not require you to bring your voter registration cards to the polls, but 2/3 of states do expect you to provide another form of ID. The other states use other methods such as signing an affidavit, providing a signature, and providing personal biographical information, like a birth date. Florida does require voter identification, such as driver's licenses, US passports, student IDs. There are 12 different acceptable forms currently. And if you don't have a signature on one ID, you must present a second ID that includes a signature. So my final slide, when thinking about voting rights and bringing it to the present moment, I thought about the different attacks that we've had over voting rights over the years. And these 3 cases, while there are many more, were 2 that I wanted to highlight. So Shelby County v. Holder nullified Section 5 of the Voting Rights Act by ruling that the relevant preclearance formula prescribed in Section 4 was unconstitutional. So Shelby, contrary to the way a lot of people think about it, did not actually rule Section 5 to be constitutional. It ruled Section 4 to be constitutional, but they work in tandem. So Section 4 prescribed a coverage formula to determine which jurisdictions were subject to a pre-clearance requirement required in Section 5. So Section 4 identified the jurisdictions and prescribed the formula, and Section 5 actually requires the permission from the federal government. And so when the Supreme Court gutted and ruled unconstitutional Section 4, Section 5 was rendered inoperable. So immediately after the nullification of Section 5, states began enacting a flood of suppressive voting laws, many of which you'll hear about very soon from my colleagues. Prior to Shelby, Florida was not covered as a whole, but 5 counties in Florida were. One other thing of note for Shelby County is the burden shift that it created in voting rights. So prior to Shelby, jurisdictions used to have to prove that their voting laws were valid. So they would have to submit those voting laws to the federal government for pre-clearance. However, after Shelby, that burden was shifted to the voters to prove that they were in fact disenfranchised under Section 2. And you'll hear later in following how Section 2 has also been diminished. So in Brnovich versus DNC, the Supreme Court diminished the ability to successfully bring claims of discriminatory voting rules under Section 2. It upheld 2 suppressive voting measures in Arizona, and the court held that the disproportionate burdens on Native Americans, Hispanic Americans, and African Americans were acceptable because the burdens were insignificant and sufficiently compensated for by the existence of other voting opportunities. So this ruling was criticized by many for essentially legalizing voter discrimination. Finally, Moore v. Hopper is a pending United States Supreme Court case related to the independent state legislature theory. It arises from the redistricting of North Carolina's districts following the 2020 census. While I won't get into the nuances of the independent state legislature theory here, primarily this case will decide the power that state legislatures wield over congressional and presidential elections. That's it. Thank you.
Thank you, Methlita. I'm going to, Cecil, I'll let you take over, talk about the recent Florida legislation and legal challenges.
Okay, I was trying to take notes. Methlita was covering the ground. That was great. Well, I'm going to focus a little bit more on our state of Florida. I think many people in attendance are from that area. And our legislators have been super busy. Every time the citizens or get something going, and I know Neil's going to talk about that with our thunder gets stolen, and with regards to Amendment 4, but I'm going to be focusing more on some of the actual voting procedures. And the first big one that we want to talk about is Senate Bill 90. And all the voting rights activists and people who try to have more people voting, we all testified, and many legislators testified, that some of the legislative elements of Senate Bill 90 would be disastrous. And it really, really has. So I want to say that the League and some of our partners, we got together, and Black Voters Matter and others, and we sued. And the things that they had done, which I will talk to you about in just a minute, most of it was undone. And so we had a momentary victory, and the state has appealed, and our victory has stayed. So what I'm going to really do is tell you what Senate Bill 90, what the limits are, and we'll just keep our fingers crossed that we'll get some relief in the appellate side. Never know. So basically, one of the first things that Senate Bill 90 did is it tried to look for ways that things had become very, very convenient for people, like a Dropbox, right? I use a Dropbox all the time because of my hours, and I missed the 5 o'clock cutoff, so I just drop it off on my way home, maybe 8:30, whatever time I get out of the office. And it was great, and we had it there for over 10 years. Was never molested, never bothered, right out front from our supervisor of election. Very sturdy. Well, they said that's too efficient because that drop box was available for 24/7. And that was the law that allowed it. And guess what they said? All of you people that do shift work, all of you people that have multi-generational families and obligations, those of you people who may have disabilities, you're going to have to figure out how to get and use this concept during regular business hours. I mean, it's so backwards. The concept of a Dropbox really expanded because people could drop their early votes in there. They could during certain times and their ballots. It just made things very, very convenient. So now you have to go inside. You have to drop. You have to go inside, and it's drop boxes are only available during early voting, which is varies by county, and during regular business hours. So that just makes it a lot harder to just drive by or park your car and drop it in. We're very, very concerned about the impact, and we don't think everybody knows. So let's all do all that we can to share that information that our 24/7 drop boxes are gone. Um, Related to that is they made it illegal for people to help other people deliver executed ballots. And they said before they took away the right for people to do it for pay. But those of us who just volunteer, which most of us are in the volunteer kind of realm, and the organizations we work with, we weren't allowed to do it now. And so, guess what? It is now a felony. And that it's a felony because it started out in Senate Bill 90 as a misdemeanor, but every year they keep trying to add more to it. So this year, Senate Bill 524 added onto that burden, and now it is a felony. If you possess, not only do you cannot deliver, you cannot possess more, in an election cycle more than 2 ballots that are outside of your family. Your family could be your married family and your blood family. If you're outside of that sphere, you cannot do it. So many of our churches and synagogues, places of worship, a lot of times a faith leader to encourage civic engagement. I know I've seen it at my church, and pastor would say, "Hey, everybody who wants some help turning in their ballots, Deacon Smith is going to turn it in for us next week." And everybody would bring their little ballot. No one was told what to do, how to vote, but they would just have it in their thing and put it in. And Deacon Smith would drive down 30 ballots for people who might have a difficult time getting it in. Cannot do that anymore. So be aware and spread the word about that. They also seem like they want to put the squeeze on third-party voter registrants. And what are those? Third-party voter registrants are agencies or individuals that want to help people register to vote and answer questions. And you often see people register to vote. And I even got my vote pin on today. Register to vote, and you might be sitting outside a store, a Walmart, a library, and you have your little signs and you're friendly. And people that have questions like, "Oh yeah, I did. I'm gonna take a minute. I just moved into town," or whatever, and you can answer their questions and you turn everything in. Well, now they said that if third-party voter registrant organizations don't turn the executed petitions for applications for voting registration in within the allotted time, which is 14 days, then you can receive a fine, and the fine has been increased. The maximum fine against an individual or third-party voter organization used to be up to $1,000 a year, which is that's not something to sneeze at. Guess what? 524 did. They made it $50,000 a year. It's obscene and crazy, and we are concerned that people don't know about that. And if they learn about it, they may say, maybe we don't need to do that third-party voter registrant work. Now, you ask yourself, why are they doing all of this? And I ask you all, if you have the time, and I'll ask Alexis to put it in the chat if she can, read Judge Walker's order. It's, I believe, 280 odd pages, but it really, really explains the history of the limitations on voting and it does touch on Amendment 4, Neil, but it goes over the consistency of literally over 20 years of, and this is the thing that's in that case. In that case, the judge actually heard testimony, and he heard from experts, and he asked the legislators, or people asked while he was observing the trial. They said, did you ask the Division of Elections how different races and groups voted? And they said, yes, we did. So they admitted that they knew how different ethnic, racial, brown and black and white, and different economics voted. And so the judge said, if you have 4 different statutes, which he went through the 4, where the way that primarily African Americans have increased their voting, every time, before it was early voting, then drop boxes, then third party voting, every time, Amendment 4, every time it had an impact that would elevate the Black vote. And miraculously, the very next year, there would be a new statute to limit that methodology. So it was very, very targeted. And guess what the judge found? He said, and you can find this approximately page 32 and page 65 in the 280 plus order, which I've read several times because I'm so gleeful, because he actually put the evidence there and the finding. And I think this is one of the most important findings of the last 20 years. He said that the legislators, which have been dominated by Republicans in the last 20 years, have intentionally targeted African American voters to hurt them, not because they don't like how they look or they don't like their fro necessarily, but because they tend to vote Democratic and they just want to hold on to power. So that's really something for you to keep your eyes on. That case is up on appeal on the 11th Circuit. We got a lot of good remedies, which I'm not even going to talk about, but it's up on appeal, and they're going to be doing their oral argument September 15th, 9 o'clock in Miami in the federal court. So I don't think they're going to let people watch because maybe don't have that there, but we can get the tape later. And last thing I'll say about that is that the Department of Justice has decided to weigh in, and they filed an amicus brief on behalf of the League of Women Voters and other plaintiffs. So we're, again, just keeping our fingers crossed and hoping that we can get some relief. Thank you.
Thank you, Cecil. Very, very helpful, useful information to know. All those links are on the chat, and I believe Alexis will be sending copies of those around to everybody at the end of this CLE. So you should all get a copy of it. It is definitely very important reading.
I want to mention one more thing that I guess it's not Neil, but anyway, the League and FRRC, we have programs where we have attorneys, pro bono attorneys, that we want people to call us, either one, and get a referral to a lawyer that's been trained to look at your sentence, because we've had some terrible things going on with people being arrested. So we want to just throw that out there, and that's one of the flyers. And I'll let Anil cover everything else. Thank you.
Thanks so much. With that, I will turn it over to Jack Genberg on the issues of redistricting here in Florida.
Thank you. And thank you, Alexis, for handling the slides. So my topic is going to be probably a little bit more complex and technical as redistricting is, but I'll try to make it relatively simple. So we could start with the next slide, which start with the basics. So basically, what are we doing with redistricting? What are districts? So districts it's essentially the lines or boundaries that group people together in order to vote for a representative. So within a district, all the people within the district vote for one representative. And there are districts for congressional seats and for U.S. Congress from Florida, state legislative, so state House and state Senate, and then local. So that could be like city council, county commission. So why do we redistrict? Well, we do it because people move around, populations move, and it wouldn't be fair to keep the same lines and have some districts with fewer people and some districts with more people. If that were the case, then the districts with fewer people, those voters would have relatively more political power. If you had, for example, a district with 100 people and a district with 10 people, the district with 10 people would have, each voter would have relatively 10 times more voting power. So redistricting is done in order to maintain at least relatively equal population among districts. And it's done generally every 10 years after the census comes out. So the census keeps track of where people are moving, and then we have a good sense of where people are, and based on that information, redistricting takes place. Who draws the maps? Usually that is, or often it is, a legislative body. So for the Florida kind of state maps for the US Congress, for state House and state Senate, that's done by the legislature. And local maps are often done by legislative bodies as well. Might be city council, maybe county commission draws those redistricting plans. We can go to the next slide. So there are a number of different laws around redistricting, and relatedly, legal challenges brought when those laws are not followed. So first one I kind of alluded to earlier, one person, one vote. It's around that equal population. So that equal population requirement is in the Equal Protection Clause, or has been found by courts to be protected by the Equal Protection Clause. Congressional districts in particular have to be very close to equal population. The language is as nearly as is practicable. And often that is essentially exactly even population. So every district has the exact same total population, plus or minus one person. State legislative districts generally are afforded a little bit more leeway. Those like substantially equal as some of the language that Supreme Court has used. Generally about a 10% overall deviation is presumptively constitutional. So typically districts are, the population is, what the population is determined based on total population of the people in the district. And this equal protection challenge has been applied to prison gerrymandering, which is essentially the counting of incarcerated population as being residents of the local prison in the district where they're incarcerated, rather than the community they came from. And this has been challenged. Recently was challenged in Jefferson County. The commission and school board redistricting plans were found to violate the Equal Protection Clause because they counted the incarcerated population in the prison, and that was viewed by the court as unlawfully inflating the political strength of the residents in that district, and then by proportionally diluting the voting strength of residents in other districts. The court found that the incarcerated population was not meaningfully represented by the office holders elected in that district. We can go to the next slide. Okay, racial gerrymandering. This is prohibited also under the Equal Protection Clause. Race cannot be the predominant factor driving district decisions. unless it is narrowly tailored to achieve a compelling government interest, such as compliance with Section 2 of the Voting Rights Act. And I'll get to that in a little bit, what that means to comply with the Voting Rights Act. But this is, I think, something people may understand about terms like packing. So that is when you concentrate voters of color into one or a couple districts to reduce their, essentially they can win those districts by a large amount, and then there are fewer voters of color to vote in other districts. And if the goal is to reduce the voting strength of people of color, those remaining voters would then be cracked, and their population numbers would be kept below the numbers necessary to elect their candidate of choice. So that would be a form of racial gerrymandering, which is unconstitutional. And there's a current case going on. Actually, Matt and I are counsel on the case with SPLC, and ACLU of Florida and the Harvard Election Law Clinic are also on the case. Is a challenge to Jacksonville City Council and Duval County School Board redistricting plans as racially gerrymandered. The plaintiffs allege the council sought to maximize the Black concentrations of several districts, and there is a pending request for a preliminary injunction for the court to enjoin the use of those maps in upcoming elections. And that oral argument for that motion is actually next Friday, the 16th. We can go to the next slide. So Section 2 of the Voting Rights Act, I talked about this before. Matt alluded to this in general context. It also applies to redistricting, and there are a number of technical requirements, but basically you have to be able to show that a racial minority group is sufficiently large and geographically compact to constitute a majority in a single member district, that that racial minority group is politically cohesive, meaning they kind of vote the same way, and that there is a and that white voters generally vote as a block the other way to deny people of color their preferred candidates. And if this is shown, you don't need to show that there was an intent to discriminate or intent to dilute the voting strength of people of color. It's just if these conditions are shown and various other under the totality of circumstances test, if that shows that there's less opportunity for Black voters or other voters of color, then and the result being that Black voters and other voters of color have less opportunity, then a additional majority minority district or majority Black district will be ordered by the court. We can go to the next slide. So intentional discrimination, intentional racial discrimination is a violation of the 14th Amendment. In the voting context, it's a violation of the 15th Amendment as well. And we have a pending case now on that in a challenge to Florida's congressional redistricting plan under the 14th and 15th Amendments. The plaintiffs allege the governor, quote, bullied the Florida legislature into adopting a congressional map that, quote, reduces the number of Black opportunity districts in Florida from 4 to 2 based on invidious discrimination against Black Floridians. And so that case, I don't believe they brought a motion for preliminary injunction. So that is likely to be aiming at getting a new congressional map for the 2024 elections. And that's there's currently a pending motion dismissed before the court in that case. We can go to the next slide. So Florida's fair district amendments. So all the other laws I talked about were federal laws, federal requirements. Florida's voters imposed upon the legislature additional requirements. It called the Fair Districts Amendments. 63% of Floridians voted to enact these amendments. So these amendments establish a number of standards for the legislature in addition to the federal requirements for the state legislative and the congressional map. Next slide. So the two main requirements in these amendments I want to talk about today. The first one is diminishment. So the legislature cannot draw districts with the intent or result to diminish racial or language minorities' ability to elect representatives of their choice. Specifically, that means the legislature can't eliminate majority minority districts. It can't weaken historically performing minority districts. We're doing so would diminish a minority group's ability to elect as preferred candidates. And this involves a comparison of the existing plan with the plan the legislature passed. Next slide. Next slide, please. Thank you. And then the other requirement under Fair District Amendments I want to talk about today is partisan gerrymandering and relatedly favoring incumbents. So the legislature cannot draw districts with the intent to favor or disfavor a political party or an incumbent. And so this was previously something that had been done more regularly, and now it's forbidden as of 2010 and the passing of Fair Districts Amendments. Next slide. So the final slide here is about Fair Districts Amendments cases. So 2012 was first redistricting that took place following the Fair Districts Amendments passage. And the legislature ran into a number of problems with its redistricting plans. So the Senate plan, the Florida Supreme Court found the Senate plan was drawn with the intent to favor a political party and incumbents, and also consistently neglected other standards of including equal population, compactness, and utilizing political and geographic boundaries, and its failure to utilize those boundaries. And then also the congressional plan, the Florida Supreme Court found the legislature had made a, quote, mockery out of the Fair District Amendments in drawing the congressional plan, and that the entire map was, quote, tainted by unconstitutional intent to favor the Republican Party and incumbent lawmakers. And then it ordered the legislature to redraw 8 congressional districts. Current case, there's a challenge to the 2022 congressional plan. That case was brought and challenges the intent and effect of diminishing Black voters' ability to elect candidates of choice. And also the case is alleging there was an intent to favor the Republican Party and disfavor the Democratic Party. So with as far as the diminishment standard and allegations go, the plaintiffs are alleging that 4 districts that were electing Black preferred candidates in the prior map, congressional districts 5, 10, 20, and 24, were all destroyed or rendered now incapable of for Black voters to elect candidates of choice in those districts. Specifically with Congressional District 5, there was an allegation that the district in the prior map had a 46.5 Black voting age population. That means the population 18 and older was close to 50%. And the allegation is that Black voters were able to elect candidates of choice with other voters of color and white voters voting alongside them. But the new map breaks that into reduces that voting age population all the way down to 11.8%, and then correspondingly moves Black voters into other districts which have lower Black voting age population percentages at 23%, 16%, and 29%. And so the allegation is that none of Black preferred candidates can win in any of those districts. So a district that was electing Black preferred candidates was broken up, and what was created was a few districts in which none of the Black preferred candidates could win. So that's kind of the cracking that I mentioned earlier. And in this case, a temporary injunction was sought, and the circuit court found that the plaintiffs were likely to prevail on the claim that the Congressional District 5 violated the non-diminishment standard, that it would diminish the ability of Black voters to elect their candidates of choice. However, the Court of Appeals stayed the injunction, stating the temporary injunction was very likely unlawful, as it was not being used for the purpose of preserving the status quo. And so that temporary injunction ultimately failed, and it appears that the 2022 congressional plan as passed is likely to be used for the 2022 elections. And however, this case and the other case challenging the intentional discrimination will proceed, and presumably are going to seek relief for the 2024 elections. So that's all I have. Thank you.
Thank you, Jack. Again, hugely important discussion and issues here. So I appreciate all the work that you and Mathlita have been doing on this. With that, I'll turn it over to Neil Volz to talk about rights restoration and the work you've done on that issue.
Awesome. Thank you so much for the time. I have been diligently taking notes myself, and I am cognizant of the time constraints we have. So I'm actually going to start with the right here and then kind of work back in the conversation. Right now here in Florida, we have dozens of Florida citizens who have been arrested for voting. And they all have one thing in common. They're folks like myself with past felony convictions. We like to call ourselves returning citizens, so that's language I'll use for the conversation. But I do think, and I really appreciate being able to carve out a little bit of the conversation specifically around voting issues surrounding returning citizens in our state, because there's a long storied history that got us here. I am not an attorney, so I'm realizing that y'all are really, really smart and digging into the statute. So my presentation might be just a little bit different, but I will speed it up because I know we have questions and answers. And I did put some information in the chat, in particular for any attorneys who are interested in getting involved in right here, right now with the issues that we're dealing with around voter eligibility. We have an attorney assistance program, and there's an email on the bottom of that any attorney who would like to get some more information can connect with our attorney lead on that program. Her name's Ideal. But about 150 years ago here in Florida, like other states, there was a Jim Crow policy that went into effect, which permanently barred people from voting for having a felony conviction. The original intent of that policy was to disenfranchise newly freed African Americans and to diminish their political power. Of course, what we've seen over time is when you institute a policy of hate and discrimination, it's like cancer, and it grows. And it grew to the point that by 2018, when we passed Amendment 4 here in Florida, there were 1.4 million people impacted by the lifetime ban on voting. And we saw that nearly 2/3 of the public voted to end that lifetime ban. An amazing kind of grassroots movement that was built around that, collected over 1 million petitions across the state. And that movement is still alive here in Florida. I think it's important to kind of know, because it seems like every cycle, 2020, suddenly people with felony convictions voting, and the fines and fees requirements were right dab in the middle of the political campaign. And here we are again talking about people with felony convictions voting in the state of Florida. So we very much as a community feel like we're on the front lines of this battle for democracy. And definitely encourage folks to kind of check out the stuff that I put in the chat for any kind of further information. But after Amendment 4 passed in 2018, we saw Senate Bill 766 work its way through the legislature. Some of the top lines of that piece of legislation included requirements for people to pay certain financial obligations, including restitution, fines, and costs before being able to secure the vote. So what we saw was this 1.4 million people, this new constituency that was kind of birthed in 2018, suddenly cut in half, where you had hundreds of thousands of returning citizens who were eligible to vote. And then now we had people who owed financial obligations who are not yet able to vote, even as the lifetime ban no longer applied to them. So included in Senate Bill 766 were some key provisions that we all worked on to try and get included into the bill. Specifically, an ability to modify somebody's sentence, to get into the court to modify somebody's sentence, either to eliminate the financial obligations or to turn those financial obligations into community service hours. But it provided some flexibility, and we're still learning as we speak. We're trying to operationalize these provisions in different courtrooms and in judicial districts across the state in terms of just what can be done in terms of modifying somebody's sentence. We've seen sentences completely eliminated. We've seen people get community service instead of their legal financial obligations. As an organization, we also jumped right in to begin trying to operationalize this new legislation, and we created our fines and fees program. And we were successful in the 2020 cycle. We started in 2019 and raising about $30 million to pay fines and fees for about 40,000 Florida citizens and to tear that barrier down that exists to voting. But the truth is, none of us should have to do that. We shouldn't be in this situation to begin with, but because of the constraints in Senate Bill 766, that is the world that we live in, and that's the world that we continue to operate under. Our fines and fees program includes an attorney assistance program, which we have hundreds of pro bono attorneys who are willing to work one-on-one with individual returning citizens to help them kind of walk through the voter verification process. And that is something that's incredibly important right here, right now, as we see what's happened in recent weeks and months as returning citizens have been arrested for registering to vote and voting, even though the state doesn't have a clear verification process. And cannot determine with certainty or give people assurances on the front end of the voter eligibility process that they are in fact registered to vote. And so what we're seeing is a confluence of, in a political campaign, a confluence of two different standards. One, there's a standard that exists that's been around for a long time that involves removing somebody from the voter rolls. There's a process in place based on the preponderance of evidence that if somebody, if there's a determination that somebody is not eligible, that voter is contacted and given time, 30 days to determine, kind of work with the state, the government, to determine whether they are or not eligible to be on the rolls, and they can be removed from the rolls. And that is a different standard than the standard to deprive people of liberty based on the voter fraud statutes in Florida, in which you have to be able to prove that somebody intended to defraud the system. And what we're seeing across the state in all these dozens of cases is that people went to the DMV, people talked to the government, people got their voter identification cards, their voter eligibility cards, and it was their thought, according to what they're saying in the affidavits and publicly, that they were eligible to vote. And we are trying in this moment in time to use this horrible situation to point to just how broken the system is on the front end. As a returning citizen, the example I tend to use is that, you know what, if I want to apply for food stamps, right, they are quickly able to determine my eligibility on the front end, and I can know whether I can or cannot operate within that system. But that is not the same situation that people with past felony convictions get when it comes to voting. What we've seen are people who are registered to vote. They think they were eligible. The state gave them the appearance, at least, that they were eligible. And now 2 or 3 years later, they're getting arrested by SWAT teams, you know, who come in at the night or early in the morning and grabbing people out of their houses in underwear, you know, and suddenly we have these high profile arrests. Mind you, all of them are people with past convictions. And we just know that we need to fix this process. Other states have statewide databases that can make voter determinations on the front end of the process. This is not something that's brand new. It is a bigger deal because of the passage of Amendment 4. But if you recall, during the Bush-Gore elections in 2000, there were thousands of people who were taken off the rolls because they were supposedly returning citizens, only to find out later that they actually were not. So this is a long-standing problem. And we are, sorry, I'm seeing the clock. And we are actively engaged in all aspects of this, but in particular for this call, if there are attorneys who are interested in helping with the voter eligibility process or want to help returning citizens, I know that we have set up a bail fund. We have set up a legal defense fund. We want everyone who is arrested for voting in this state to be able to get out, to have counsel so they can make the wisest choices for themselves. And then we're going to see how this plays out in the weeks and months ahead. Was that fast enough?
That was, Neil, thank you. I mean, you covered a lot of very important information here. So I would add that, again, the link to your organization is on the chat here, FloridaRRC.com fines program. And that's actually segues to one of the questions we have here, and I do realize we're a little bit over on time, but one of the questions the viewers had was that, you know, how do we help returning citizens who have been charged for these particular crimes? Your organization is one of the organizations that's sort of helping bring that issue together and bringing lawyers together to work on that issue, correct?
Yeah, we have a lot of attorneys who we're working with, and I would just say, and again, man, I'm not the attorney, so I might not use all the right language, but we see the chronology of this as like immediately supporting returning citizens with kind of a two-step process of let's get them out of jail. I mean, I've talked to people who've spent 6-7 days in jail and went through this process, and they thought they could vote. Their grandparents, their family members. And so we don't want them to be in a situation where they're feeling the coercive pressure of a plea agreement. We want to make sure that they get counsel so that they can make wise choices as this thing moves forward. And then I know there's a lot of attorneys engaged in conversations about potential litigation and things like that as it relates to kind of the bigger picture. But what we've done is to try and jump in and really focus on the individuals who are directly impacted. Because of the dozens who are arrested in our state, the one thing that holds it together is they're all people with past convictions.
Thank you, everyone. Thank you, everybody, for panelists for speaking to all these very important issues. Alexis has posted to the right here on the chat the CLE code for everybody here so that you can get credit for being here. I know she'll follow up with everyone with the documents that were referenced here today and links. Alexis, I'll turn that over to speak about that. But I just want to thank all the speakers here individually. Thank you for the work you do. I appreciate the time, and thank you for listening today. Alexis.
Yes, thank you so much. This was such an incredible panel, really important topic, and you all just have a wealth of knowledge. So thank you for giving us a chunk of your time. I know how much I enjoyed it, and I can only imagine all of the participants as well. I did put the CLE code into the chat. That code is 6560. In 24 hours, you will receive an email from Zoom. It won't be from my email address, and it will include a copy of this recording, the materials that are posted into the chat, and anything else if our speakers send me anything else before then. Last housekeeping matter, this was co-hosted by the Public Interest Law section of the Florida Bar. Please join. It's a great section of the Florida Bar that does really important stuff for all of these different sections sections of public interest law. So we'd love to have you be a part of it. And that information is at the top of the chat and will also be embedded within the follow-up email that you will receive in 24 hours. So enough of the boring housekeeping. Saab, is there anything you'd like to say to close it out? Or I always usually offer to my panelists if there's anything else you want to say, at the end.
Absolutely. Yeah. I'll turn it over to the panelists if they have anything. But other than that, thank you, everyone.
Say thank you, everyone.
Thank
Yeah.
you.
Thank you for all the work you all do.
Absolutely.
Well, you all have a wonderful Friday and a fantastic weekend.
Thanks.
Bye.
Okay.